Welcome everybody to the CPR Government and ADR Task Force meeting and presentation. I'm Ellen Parker. I am Senior Vice President of CPR Institute and really happy to have this program today and our speakers. A little background on this task force. The Government and ADR Task Force is a standing task force designed to educate companies, law firms, and government agencies and their individual attorneys on the use of ADR in both the federal, public, and private sectors, and the specific requirements for engaging in ADR with certain government agencies. The task force encourages the increasing use of ADR in public-private disputes, as well as the development of new ADR solutions for these disputes. And as an information clearinghouse, the Government and ADR Task Force tries to bridge the gap between government and business by facilitating mutual sharing of ADR best practices. I think today's program meets this mission perfectly. Participation in the task force is open to both CPR Institute members and non-members alike. It's one of the few that we do. The chair of this committee is Pete Swanson, Director of the Office of Conflict Management and Prevention at the Federal Mediation and Conciliation Service. And with that, I turn this over to Pete. Thank you.
Ellen, thank you so much. Hello, everybody. Happy Tuesday. Happy lunchtime. I'm glad you could join us for today. Joining me here as a co-presenter, co-facilitator, you'll see my dog, Lily, who is made herself very, very comfortable there in the background. And she's so excited to hear me talk about this. I am really happy to actually be here today doing this program on ACUS with CPR. The reason being is because I've had a wonderful relationship with ACUS going back to 1989-90 when I first came into FMCS, and we were both involved in working on ADR in the federal sector at that time as it was just beginning, and we partnered a lot. And it was at that time that ACUS got really involved with CPR as well. So the nexus between the three organizations goes back decades. And so this was really exciting to work with CPR today to bring ACUS to the forefront. And what we're going to do for the next hour, everybody, is I'm going to introduce you to Jeremy Grayboys, who is the Director of Public Policy and Interagency Programs at ACUS. He's going to tell us a little bit about ACUS. And then we have the pleasure of the heart of the program is to talk about the wonderful study they did in ADR and agency administrative programs by two of the three authors there that we have with us, Kristen Blankley and Judah Starr. I'll talk about them in a little bit, but they're going to give you an overview and the recommendations from their report. And then we're going to have some time for questions and answers. And then we'll do a wrap up and we will be finished by 1 p.m. Eastern, but that's how we're going to spend our time. It's a delight to have everybody on. And Jeremy, I'm going to turn it over to you.
Great. Thanks so much, Pete. And thanks also to CPR and Ellen and Carrie Ann for putting together today's program. So as Pete mentioned, I work with the Administrative Conference of the United States, or ACUS. For those who don't know us, ACUS is an independent federal agency within the executive branch whose statutory mission is to study the efficiency, adequacy, and fairness of federal administrative processes. Established in 1964, the agency is charged with promoting effective public participation in the regulatory process by reducing unnecessary litigation and improving the use of science and the effectiveness of applicable laws. ACUS is a uniquely structured federal agency. We're headed by a Senate-confirmed chair and have a small professional staff made up mostly of attorneys. But in addition to the chair and the staff, we have what's called our assembly. Along with the chair, the assembly is made up of 10 presidential appointees, 50 senior officials designated by the heads of participating federal agencies, including all cabinet agencies and independent regulatory agencies, and 40 academics, practitioners, and other experts from across the private sector. Except for the chairman, all members are unpaid. So since the 60s, ACUS, the ACUS Assembly has issued more than 270 recommendations, I think it is now, to improve rulemaking, adjudication, and other administrative processes. Many have resulted in reforms by federal agencies, the President, Congress, and the Judicial Conference of the United States. ACUS also commissions research reports, prepares source books, organizes forums and roundtables, and conducts other activities to study and improve federal administrative processes. One area in which ACUS has long been active is examining how agencies use and could better use ADR to manage federal administrative programs fairly and efficiently. ACUS issued a string of relevant recommendations back in the 80s and early 90s, the period Pete was talking about. Those recommendations addressed agencies' use of ADR generally, the use of ADR to negotiate proposed regulations, best practices for acquiring neutrals, ADR as a case management tool for improving adjudication, ADR confidentiality, and the use of ADR to resolve disputes arising in particular contexts. For example, cleaning up Superfund sites, resolving disputes involving government contracts, FOIA requests, housing discrimination, farm debt, and ADA violations. ACUS also published a variety of ADR-related reports and source books during this time, including a practitioner's desk book developed in partnership with the CPR Institute back in 1995 called the ADR Breakthrough for Government Contract Disputes. Most significantly, ACUS's efforts led in large part to passage of the Administrative Dispute Resolution Act in 1990 and 96, and the Negotiated Rulemaking Act in 1995. In fact, both acts designated ACUS as the lead agency responsible for coordinating ADR and negotiated rulemaking. Although that role has changed a bit over the years, ACUS remains active in the ADR space and continues to study how agencies use and could better use ADR to administer federal programs. In the last decade alone, ACUS has revisited how agencies can use ADR to resolve Freedom of Information Act disputes and negotiate rulemakings. ACUS also undertook an important project, the use of ombuds in federal agencies. About 2 years ago, ACUS launched a new project to investigate how agencies use and might better use different types of ADR to resolve matters related to their core statutory authorities. Although there has been fantastic work on the use of ADR for federal labor and employment matters, procurement, and FOIA, there had been considerably less cross-governmental study of how agencies use ADR to resolve matters with external parties on matters such as regulatory enforcement, licensing and permitting, and access to government services and benefits. We were interested in learning more about the selection and implementation of the appropriate type of ADR and associated procedures in such contexts, the qualification, selection, and training of agency ADR personnel, ethics and confidentiality requirements for agency ADR personnel, ADR case management practices, and interagency mechanisms to facilitate ADR and support agency ADR practitioners. We secured a fantastic team of consultants to undertake the study, Kristen Blankley and Judith Starr, who are here today, and their co-author, Kathleen Clausen. They'll tell you more about their findings in a minute, but I encourage you all to read it. Besides being an important report, it's a really interesting one. You can find it on ACUS's website if you go to acus.gov/ADR report. We've also recently established an ADR advisory group to advise ACUS on potential new initiatives to improve the design and administration of ADR programs across the federal government, and we're pleased to work closely with Pete and FMCS through that endeavor. So Pete, let me turn it back to you.
Thanks, Jeremy. I certainly appreciate the setting the stage for this presentation. And if anybody has ever, if you've never run across an ACUS study or recommendations, let me tell you, they certainly do their homework. When they produced the negotiated rulemaking handbook back in the early 1990s, that thing weighed 5 pounds and was over 1,000 pages. It was huge, but it was the Bible for negotiated rulemaking and stands up well for that document today about how it's done. So they do their homework and they do it very, very well. And this study is no exception. So let me introduce you to Judith and to Kristen, because they've really got some heavy hitters on this team who did the study, and they're going to walk us through the highlights of that study. So who is this team? Judith Starr. Judith retired from the federal government in December of 2019 after a career that included serving as the Assistant Chief Litigation Counsel for the Securities and Exchange Commission. She was Chief Counsel at the Department of the Treasury's Financial Crimes Enforcement Network and General Counsel at the Pension Benefit Guarantee Corporation, where she founded the agency's regulatory enforcement mediation program. She mediates for the local courts, serves as the Florida Mediator Qualification and Disciplinary Review Board, and for AAA and commercial mediation panels and FINRA arbitration panels. In 2021, she founded Suncoast Community Mediation, a community mediation center. And joined with Judith is Kristen Blankley, who is the Henry M. Grether Jr. Professor of Law at the University of Nebraska, where she teaches a variety of ADR courses, including mediation and arbitration. She writes primarily at the intersection of ADR and ethics. And Professor Blankley is a practicing mediator, facilitator, and arbitrator. So we've got some really good folks who were on this study. If you have questions, everybody, by all means, could you please put them in the chat or raise your hands? I don't know how many people are necessarily on here now, but what I do know is if you raise your hand, your picture goes to the queue and we can see who's raising the hands up there. They encourage you to ask questions as we go along. We're going to go along for about 20 or 30 minutes on this, and then we'll have some time for additional questions and answers at the end. So Judith and Kristen, over to you. And I will go off camera, so it's all about you now.
All right. Well, we can't do anything without a PowerPoint slide presentation. So let me just get us going in slideshow. And here we go. So we're going to start with Kristen talking about our methodology.
Yeah, thanks, Judith. And thank you all for being here again. We are watching the chat if there are questions that come in. And so this was a project that was about an 18 to 24 month project that was started in the summer of 2020. And our final report was adopted by ACUS and published by ACUS in December of 2021. And thanks to Jeremy, he outlined, we were given 6 research areas, and Jeremy kind of outlined those 6 research areas, and we will go over each of those areas. What you'll see in the report is a brief description of our methodology, and then for each of those 6 research areas, you will see that we provided an academic background for each of those 6 areas. We reported on our findings of each of those 6 areas, and then we made recommendations. So each of those six parts of the report, major parts of the report, kind of follow a similar structure as you read it. And what we were really looking at is figuring out, trying to get a handle of all agency ADR as it related to outside stakeholders. And as Jeremy mentioned, we specifically excluded all EEO dispute resolution. And so we were looking at agency ADR, particularly as it related to those external stakeholders, including the public enforcement agencies, etc. In order to do this, we gathered information both from agency personnel as well as from publicly available information. And our scope included 17 cabinet agencies as well as 17 independent agencies. We started with the ACUS reps, and ACUS reps, we identified the ACUS reps and asked for some contacts either within the ADR departments or legal counsel responsible for ADR within that agency. We created a survey, and we deployed the survey to as many agencies as we could. We received 12 survey responses from 12 different agencies. In addition, we conducted interviews with personnel from 16 different agencies regarding their ADR projects. For some of these responses were focused on one specific program, particularly if there was only one program. Others were an amalgamation of what multiple programs at different that the agencies were working at. We conducted 16 interviews for 9 agencies. We did receive information from both surveys as well as interview information, and we did additional website research to fill out our information on those who did not participate either in surveys or in interviews. We did significant outreach, again, in addition, by working through ACUS and ACUS contacts. Judith has amazing relationships from her work in federal ADR that she helped leverage to help us do our information gathering. In addition, we also utilized the ADR working group. We presented to the ADR working group and listened to concerns and questions of the ADR working group, as well as we listened. We spoke with the Coalition of Federal Ombuds, COFO, and listened to some of their questions and concerns. At all of these outreach activities, we solicited input, and we solicited the ability to learn about their agency. So that's a bit about our methodology.
So I'm going to talk just briefly about the history of ADR in federal agencies. Mediation as a form of diplomacy has actually been around since the early days of the Republic, when Thomas Jefferson acted essentially as a mediator over the negotiations for the location of the nation's capital. And in the 20th century, Theodore Roosevelt actually mediated the end of the anthracite coal strike of 1902, which led to increased congressional interest in using ADR in labor strife as labor strife intensified over the next 2 decades. So when Congress created the Department of Labor in 1913, it also authorized the Secretary of Labor to actually mediate labor disputes. They then created the conciliation service at the DOL, which did that as well for a couple of decades. Until 1947, the landmark labor legislation Taft-Hartley created FMCS. And FMCS took over the DOL role and as well had a much more proactive role in preventing or minimizing the effect of labor disputes on communities and also on the economy. So as this went along by the 70s, there was a great deal of interest in ADR in other parts of the executive branch, specifically executive branch adjudication. So when the Age Discrimination Act, Employment Act of 1975 was passed, Congress empowered the then Health, Education, and Welfare Department to mediate cases under that act, and HEW brought in FMCS to do that. As Jeremy stated, ACUS became interested early on and has issued comprehensive recommendations regarding an ADR framework, which led to the 1990 Administrative Disputes Resolution Act, which sunsetted and then was replaced by the 1996 Administrative Dispute Resolution Act, which added ombuds to the different modalities that are available, and that was an important change to that. It gave agencies broad authority to implement ADR, except where there were public policy reasons not to, and it left it up to the agencies to determine if public policy reasons militated against using ADR, such as situations where you have the need for precedent or the need for a record, or there are absent third parties, or the agency needs to exercise continuing jurisdiction. But nonetheless, it was up to the agency to decide. ADRA just told them to consider it. The other thing that the ADRA 96 did was it required the president either to appoint a lead agency to coordinate ADR or to set up some kind of an interagency working group. So in 98, President Clinton chose the latter and set up the interagency ADR working group, which was to be convened by the Attorney General and was supposed to be consist of senior officials from cabinet departments and other independent agencies. It ended up actually being run by a steering committee. Then in 1998, Congress got into the environmental area of ADR and passed the Environmental Policy and Conflict Resolution Act, which created the National Center for Conflict Resolution, which has since been renamed the John McCain National Center for Conflict Resolution, to provide services and also thought leadership in the growing field of environmental collaboration and conflict resolution, known, of course, by its acronym of ECCR. So during the first 2 decades of the 21st century, the use of ADR has really grown across agencies and programs. The processes are different depending on the types of disputes, the types of parties, the varieties of outcome. And we'll be discussing the many innovations we found, starting with Kristen talking about the modalities.
And can you go one more slide to get the, that should get the next, yes, okay. And one more to get the recommendations at the bottom.
Let me go back again.
So the first, and then can you go advance one more to see if it pulls up? Go back to where we were, we're good. I think one of the things that most people wanted to know is what programs are available. And what you will see from here is that I believe the exact number is 23. We had identified 23 different mediation programs. And so mediation is the most popular type of ADR program, followed by ombuds programs at around 13 different ombuds programs. The mediation programs we see primarily in areas involving adjudication, but not solely in the world of adjudication. The ombuds programs involve primarily, service primarily the public, whether those be consumers, whether those be people holding student loans or involved in banking and other types of things. And so, and then following the ombuds programs, the third most numerous programs that we will see are actually those involving facilitation. And I want to separate out the work of the facilitators from the work of the mediators. And while I'm probably speaking to the choir here, when we are talking about facilitators, we're talking about those who are involved in large group projects and large group problem solving. And those types of groups might come about either because of agency adjudication, but could also come out in other types of various roles. And while mediation usually involves a small number of parties, facilitation often involves many, many stakeholders. And so our facilitators are working on a broader, are using different skills in order to manage those large groups. Our facilitators use mediation skills, but also skills from organizational psychology and other disciplines. You'll see that there are some arbitration programs out there, not very many. The arbitration programs are primarily run through the Department of Labor. And a couple of the recommendations that we have, or I think our first recommendation that we have, is increased visibility and availability of these programs. And one of our agencies, as that we saw in one of our surveys, had noted that many of these programs are thinly staffed, and so the more information that's out there about them, the more likely that they'll be utilized beyond the staffing capabilities. But as we were kind of looking for information on the programs themselves, we had discovered that it was somewhat difficult to find information about the programs. It wasn't kind of front and center, and keyword searches did not always bring up the places to go to find out information on these programs. And so our first recommendation, as it goes to selection and implementation, would be to increase the visibility of these programs. By definition, these are programs that interface with the public. That's what we were asked to research. And so, whether those be citizens and consumers, whether those users of the programs are companies who are facing adjudicative action and other types of clients, we would like to, our first recommendation is so that more information is publicly available, particularly on the website. Another recommendation we have, and we have this recommendation a couple of different places, but is evaluation of the programs. And to the extent possible, outside evaluation. We understand that outside evaluation comes with a price tag. And so, but to have kind of routine evaluation of those ADR programs, make sure that those programs are doing the job that they're supposed to do. And so with that, I'll turn it back over to Judith to talk about staffing.
Here's your recommendations.
There we go. Yes.
There's an extra click. All righty. So here we are on staffing. So this is a highly decentralized area. There aren't standards and practices that you're going to see government-wide. We found that staffing practices were highly dependent on agency resources, not surprisingly, and the size of the program, complexity of technical issues dealt with, and finally, also agency culture is pretty important too, because agencies have very different cultures regarding such things like contracting out, for example. So we found a couple of different models, and we found agencies also that use all of them or some of them. So they're not necessarily inconsistent with each other. Full-time employees, interagency agreements, use of private contractors and rosters. So with FTEs, we found that ombuds tend to be employees, and that's not surprising because they work a lot with employees, but also, they need to have their own organization. They need a certain amount of independence from management. And so that's the model that they tend to follow. We also found agencies with kind of technical expertise focused programs tended to use often lawyers with mediation experience and training. The Federal Communications Commission, the NLRB, the Office of Special Counsel, all use attorneys trained as mediators. Some of the administrative law judge programs use settlement judges there who are not sitting on the case. The EPA Environmental Appeals Board, for example, or the NLRB AJ programs as well. And then there are also agencies that have very strong programs with lots and lots of neutrals, such as the FMCS and the National Center, of course, also the EEOC, which has a very large mediation program, the EPA, and the Department of Interior, which has a strong centralized program. Interagency agreements can be particularly useful for agencies that are startups or that have a small budget or that have to have the ability to scale up and down because their work may change with seasons or state of the economies or whatever. The agencies that provide such services to other agencies are mostly FMCS and National Center, and they are very good for scaling. For example, Department of Education's Office of Hearings and Appeals, which has a mediation program, supplements their FTEs with an interagency agreement with FMCS. When PBGC, Pension Benefit Guarantee Corporation, when we set up the mediation program, we started with a pilot and we used an interagency agreement with FMCS. And when the program went to permanent, it continued that way because it was a fairly kind of seasonal thing, depending on what was going on with the economy. Contractors are another way to quickly obtain a large skilled ADR workforce, so long as there are knowledgeable staff at the agency to oversee the contracts. Some of the larger programs supplement their full-time employees with what are known as IDIQs, which are indefinite delivery, indefinite quantity contracts. And they're essentially a master service contract. Then when you actually need something, you have a case, you put an order against it. And you can have multiple vendors on such a contract. DOI has one, EPA has one, EOC has one. And in fact, we were able to find an example of one on the internet and actually have the URL for it in our report in one of the footnotes if people want to look at it. The final thing that we looked at, which was really interesting, was rosters. A roster, of course, is where the people are pre-qualified. Often the parties can just go ahead and pick them and pay them. Sometimes, such as the National Mediation Board, they might pick from the roster. And sometimes there are rosters that are pro bono, which was something that was really interesting. About 5% of EEOC's cases are done through a pro bono roster, and the International Trade Commission's entire program is done through a pro bono roster. These are expert lawyers in international trade. They can't be practicing before the ITC, so there are no conflicts or potential conflicts or appearance of conflicts, and they will donate 1 day of free mediation to be on the roster. If the parties want more than 1 day, they have to pay for it. So our recommendations really took some of the best practices that we saw and would like to see them across the board. First, that there should be, whichever form an agency uses, it should be within a structure with committed executive leadership in order for people to be at the table for budget, to have visibility, to have accountability, so that ADR can actually be integrated into strategic planning. One thing I heard from experts is that to be truly successful, ADR needs to be integrated into agency culture, and that means it needs to be visible and it needs to have committed leadership pushing it all of the time. One example we saw was FERC, the Federal Energy Regulatory Commission, which issued a press release when it moved its ADR program into its general counsel's office in order to increase its visibility and its access to executives. We recommend a centralized knowledge sharing of position descriptions. There's not very much of that right now, at a centralized location, so that people don't have to invent things from the scratch again, and can figure out ways to recruit neutrals and also retain them, through different levels of these things. We recommend more use of interagency agreements. We recognize that there are a lot of budgetary constraints on agencies, and interagency agreements are a very economical way to tap into very qualified neutrals and assistants. And finally, enhanced use of rosters, including looking into possibly pro bono rosters. It's another way to not just supplement staff, but you can also deepen and broaden the pool of people and the experiences that they bring to bear if you use them. So I'm going to move right into training, since it's closely related to staffing. And training really runs the gamut from basically hiring someone that's been trained and then throwing them in and making them responsible for their own training forever and ever, to very structured and deep training programs such as at FMCS and the National Center. It varies all over the place. And that's not surprising. The ADR communities like that, for example, with states, some states like my now home state of Florida certify mediators and have continuing mediation education requirements. Others do not. It's all over the map. And that is also the case with the feds. Only about half the agencies that we reviewed had formal training programs, although the environmental agencies, that was almost all of them, because they all actually have to report on that to the Council of Economic Quality, which is a great way to concentrate your attention when you have reporting requirements and metrics. DOI and EPA have strong centralized programs that deliver training across the agency. The National Center has a certification program for environmental collaboration and conflict resolution that's highly regarded. FMCS has started a 2-year certification program for its own neutrals for conflict management professionals, focusing on more comprehensive management and prevention services. Some agencies make do with things that don't really cost anything, but that can be very effective, like co-mediation, where you have a senior and a junior mediator working together, or co-facilitation for that matter. And that can also be very helpful. I mean, there are ways to do training that don't cost as much, and we hope that we have been able to provide some of those examples. Finally, evaluation of training in a formal manner is very rare. And in order to incorporate it in strategic planning, that's something that you really need to do. EPA does that, National Center does that, FMCS does that, very few other agencies. So our recommendations recognize that training is highly vulnerable to budget cycles. When I was in the federal government, that was always the first thing that went if your budget was getting lopped. But there are a lot of ways to improve training across the board without necessarily having to invest very much money. So what we've done is we've talked about both what should be in training and then how you can do it more cheaply. So we think continuing education refresher, so that mediators are not relying, and facilitators and arbitrators for that matter, are not relying on old practices and not learning best practices and learning new techniques and things that are coming up. Also certification opportunities so that there's some kind of a career progression for neutrals so that you can retain strong neutrals so they don't feel they're stagnating. Facilitation training. And some agencies do have that, FMCS again, National Center. But as Kristen pointed out, facilitation is different, as I'm sure many of you know, from mediation. And I have personally found that, training is extremely helpful. And trying to treat a facilitation like a mediation is not a great idea. Ethics training as well. Ethics does change over time. It's not a one-shot deal, and ethics for federal employees is a regular thing. And we've seen a lot of new ethics issues coming up with, for example, Zoom mediation. I can tell you that. And so it's important to keep that going. And there are ways to do training that don't cost anything, such as co-mediation and co-facilitation, which can also actually be a gain to the parties when you have a lot of logistical issues because you have multiple parties. It's really nice to have more than one facilitator or mediator. And finally, using reflective practice. Reflective practices is another thing that doesn't cost anything that can help upgrade neutral practices. Reflective practice groups are composed of neutrals who support one another by exploring the assumptions and motivations that underlie their cases. So somebody will get in front of the group and disclose a moment of uncertainty or surprise or discomfort, and the group, through asking questions, helps them to realize why that happened and how they can deal with that in the future. We do have a strong reflective practice group with the mediation committee of the American Bar Association's dispute resolution section, which if you're a member of, I encourage people to check it out. And I'm going to go over to Kristen to talk about ethics.
Right, so ethics. One of the really nice things that we discovered about ethics is that as far as the ethical legal structure, for the most part, federal agencies do have a backbone a backbone of legal requirements as it relates to ethics, and there's really two places where that comes from. The first is ethics for federal employees, which I touch on, and we touch on in the report, but don't spend too terribly much time on. More importantly, ADRA covers a number of important ethical issues, and that makes these ethical issues standard across agencies, which I do think is really useful and really helpful. And where ADRA covers ethics, it's really strong in two areas, 2.5 areas. So the first area that ADRA is particularly strong is on the definition of neutrality. And so neutrals who are working for federal agencies are statutorily required to be neutral. And our report has links to the definitions of neutrality, but that is a statutory requirement. And then the other piece that is already in place because of ADRA, the federal legislation, is not only confidentiality, but confidentiality plus a certain amount of privilege. And so there are confidentiality procedures or confidentiality statutes in ADRA, and part of those confidentiality statutes include the fact that that statements made or communications made in ADR processes are inadmissible. That is, in essence, a privilege guarantee or bestowing a privilege on those types of communications as well. So those are covered within federal law. And then the third place where we do see ethics covered in federal law in ADRA is in the area of arbitrators. And so there are arbitrator ethics or within the definition of and some of the arbitration specific provisions of ADRA. There are other issues, however, that are not covered as well from federal law, and we do see some of the agencies trying to fill this in. In particular, there are no ADR specific or process specific ethics standards and guidelines codified in federal federal law for mediators, facilitators, or ombuds. And so those are areas that I think could be looked at in order to determine whether or not federal standards should exist, or whether or not agencies should adopt standards that have been adopted other places. For example, the federal standards, the standards of practice for mediators, the IOS standards for ombuds, and others. One thing that we noticed is, and I mentioned transparency as to ADR programs, I think that, and in particular, even when you could find issues or you could find information about ADR programs, there was very little transparency, at least on publicly available website and similar types of places, information about ethics and about those guarantees of those really important principles, including neutrality and confidentiality or competence, or other key ethical components. One of the recommendations that we make is, and this says the use of confidentiality agreements, and I think it's slightly broader than that, and that is the use of engagement letters. And engagement letters can be really helpful for any ADR program. Those of you who have private ADR practices, you all have engagement letters, and the purpose of those engagement letters is to put everybody on the same page regarding the standards and regarding the standards by which the services will be rendered. And so those engagement letters, in addition to including things such as compensation, which may or may not apply for our federal agencies, but often those engagement letters will discuss how this process, whether it is mediation or facilitation or arbitration, will be confidential, that it engages in, or it recognizes the principles of party autonomy. And we link to a few agencies are using engagement letters or confidentiality agreements. We link to them in the report as examples of best practice. The last thing I want to say about ethics is this last point, and that is, and if there is one thing as it relates to ethics that I think we should spotlight, and it's not one that costs anything, is lines of communication for neutrals. For those of you who are in private practice as a neutral, you know it's kind of a lonely business, especially if you are a solo. Many neutrals are solos or in very small practices. But within the federal government, we do see that in some instances there are ADR departments, and what I think should be one of the things that should be incorporated in federal ADR practice is some line of communication, so that if ethics questions arise, the neutral knows where to go to talk to somebody about that question. So for some agencies ask neutrals or have a system in place where neutrals can talk to counsel or others, but not every agency had that kind of line of communication for neutrals. And as Judith was talking about earlier, neutrals have various roles within the agency, between whether or not they are employees or contractors or come off a roster. And we would highly recommend that agencies put forth a policy so that if you have a mediator, or arbitrator, or facilitator who needs to ask a question about ethics, whether it is a competency issue, or most likely going to be a conflicts of interest issue, where can that person go when that ethics question arises? The fifth area of inquiry that we were asked to look at is the area of case management. And in case management, we were really looking at intake, records, and platforms, as well as kind of follow up. And so most of the federal agencies that we looked at were using online case management, which we would highly recommend online case management. Depending on the size of the ADR office, we did see various types of intake procedures as well as records and platforms. In some, for very small offices, we're seeing some kind of all hands on deck in terms of who is in charge of intake and how all of that information is inputted into the records, inputted into the records procedures, etc. And for larger offices, larger ADR offices, we are seeing specific staff who have the ability to take on that role of intaking the cases as well as ensuring kind of case management as it goes along. Just briefly, as for recommendations, we understand that our first recommendation is one that might be cost prohibitive. But as with most of our other recommendations, we are suggesting some level of periodic review or audit. And for the case management, this might be a nice area for external or internal review of how of kind of case management, records retention policies, reviewing to the extent that software is being used, making periodic assessments of the adequacy of the software, particularly for issues involving confidentiality and ethics involving software, particularly if our agencies are using cloud storage, which they may or may not be, but there is increasing guidance regarding data management, and this is an area that we hope is on all of the agencies' radars.
Done. Okay. And finally, we move to interagency ADR operations. So we found 4 groups, but one of which is really not doing very much anymore. So I will talk quickly about that. As I mentioned, the 1998 President Clinton memo established the interagency ADR group, which was supposed to do encouragement, facilitation, and coordination of program development and others. And in its first decade of existence, that is in fact exactly what it did. And you can still see today at adr.gov a lot of the work that it did in many areas of concern, such as a report on how Freedom of Information Act law intersects with confidentiality of mediation. However, what happened is that this was not something that was independently funded. It was not something that was set up to be staffed by people that weren't just collateral volunteers from other things. And the website was being maintained by a DOJ Office of Negotiation that was taken out of existence in 2018. So the last decade or so of its existence, it was not a very active group. And then for a couple of years, it wasn't clear what was going to happen with the website. And in 2020, FMCS got some funding for the website, but it's not really clear what's going to happen with the interagency ADR working group. And we'll get to recommendations about that, but I'll first talk briefly about the other organizations. So the Coalition of Federal Ombudsmen, or COFO, is not really a federal entity like the other agencies. It wasn't set up by statute. It wasn't set up by a presidential memorandum. It was actually created by charter by volunteer ombuds. Is open to ombuds of all stripes, but only feds can be voting members. And it is devoted to raising professional standards and providing guidance, skills development, and helping ombuds with their effectiveness. And it does have a lot of good information on the site and good guidance and help for people, such as developing position descriptions for ombuds. It has regular meetings and conferences focused on practice, skills building, and outreach and public education. And when ACUS did their report on ombuds in 2016, The folks that they talked to at the agency cited COFO as a very strong source for guidance and support in professional development. FMCS, I'm going to talk about next. And as I have noted, its mission has greatly expanded since 1947. And now it provides conflict resolution services to industry, to government, and to communities. It does assessment and system design. It will provide neutrals to other agencies, training, education outreach to share best practices, and it uses interagency agreements that reimburse it solely for staff time. So it is a very good budgetary option. It also does dispute resolution system design. They'll do a procedures audit to look at how an agency actually resolves conflict and then come up with a soup to nuts recommendation for improving how they do it. They have their Institute for Conflict Management with wide range of classes and workshops. They will also provide customized training, coaching, and mentoring. And if you haven't been to FMCS's website, I encourage you. They have lots and lots of brochures there, and it was a very fruitful area to look at for the report. The National Center, as I mentioned before, was created by the Environmental Policy and Conflict Resolution Act of 1998, and its mission is to help the executive branch implement the National Environmental Policy Act of '69. They provide assessment, mediation, related services for conflicts dealing with environment, public lands, natural resources, tribal issues as well. They do consultations, assessments, process design, mediation facilitation, stakeholder engagement, and tribal consultation. They also have training programs, develop skills, and build workforce skills in collaboration. And as I mentioned before, they also have their certification program. The other interesting thing that the National Center does is to coordinate federal ECCR, which, as I said before, is environmental collaboration and conflict resolution, to solve problems and conflicts that arise in environmental areas that would include energy, transportation, and water and land management. In the report, we really characterized ECCR as the high water mark for interagency collaboration on ADR because it represents a community that shares knowledge and resources, has common metrics and reporting, and is able to look at across agencies at the effectiveness of various approaches. And we found that this successful interagency collaboration owes much to the fact that this community shares a common statutory framework in EPCRA and NEPA. They have leadership from the White House through the Council on Environmental Quality and also OMB, and they have the dedicated resources of the National Center. ECCR is something that does have a long history both inside and outside the government, which has really enabled agencies to embed its principles into their cultures. There is a governing memo by the chair of the Council on Environmental Quality and the director of OMB that sets forth the principles. It also sets forth common metrics and requires regular reporting. The National Center is required to convene quarterly interagency meetings to discuss what's going on with ECCR, and agencies have to report every year on their use of ECCR as well as estimated costs and savings. And if you go to the National Center's website, it has some excellent summaries of cases that they've been involved in that have included federal agencies, state agencies, environmental groups, and local residents with issues that range from environmental cleanup to endangered species protection to the impact on residents from state and federal development and impacts from tribal developments as well. So our recommendations really look at the ECCR model as something that could be used for the entire government because we see a need to continue to have an interagency coordination mechanism that the ADR working group was meant to have, but that it needs a similar framework. It never had the belt and suspenders that ECCR has in terms of leadership from an expert agency, funding to carry it on, metrics and reporting to assess benefits on a consistent and continuing basis. Somebody like, for example, FMCS, but of course, it could be someone else. We did have one recommendation also for FMCS. You will not be surprised to hear that we find sometimes the federal government operates in silos, and people don't always know that they've got this resource available and that it's not just a labor management agency anymore. And so we recommend the use of cross-agency details between FMCS and other agencies so that they can learn about each other and take better advantage of these resources they already have. And with that, I'll have Kristen talk about areas for further research.
Okay, briefly, we would like to we wanted to let ACUS know that a couple areas of research that might be useful include issues involving wellness, DEI, online dispute resolution, pandemic changes, and other ways of supporting ADR. I know we're running out of time, and we got a great question, and I think it's a question for Judith, and that's really the million-dollar question, which is, to the extent that funds are limited, what are some strategies that you're familiar with for agencies to increase their budgets in ADR?
Sure. I actually have a lot of experience in that. And as I've said, first of all, interagency agreements are really, really cheap. But, so are, going to interagency conferences and just, scooting on their websites and meeting people and talking to them and going to all of these different interagency groups and organizations that have this wealth of experience. When I set up our program, we didn't have any resources for it at all. And, I managed to scrape up some stuff for an interagency agreement, but most of what we did was learning from other agencies, from making calls and visits and, then setting things up and then trying to piggyback on other things such as, the online management and case management audits and things that were going on there. There are a lot of ways to piggyback on existing resources and use them in the federal government. The great thing about being in the federal government is that you have all these wonderful resources out there that you can leverage, and you can in fact do a lot with very little, because that's most of what we in the federal government have to do all the time. I'm going to stop sharing now and see whether we have any other questions.
Judith and Kristen, thank you so much. That was a wonderful overview. I know we're running a bit late, but I do want to allow for any questions that people may want to have. And I did want to comment just on two things. Kristen, totally agree with you about the issue of having a resource person for a neutral to talk to. We have amended all our interagency, our agreements and our agreements to engage, whatever they look like, to have a clause that will stipulate that our neutrals have an ADR coordinator that they can go talk to the case or the issue about, because we don't want them facing the challenges that you're talking about. I think that's really important. The second thing is that we're also looking at, we are managing now adr.gov, and I think we're bringing the COFA webpage under that. That's a recent development too. We're in discussions about that and about trying to see about the next steps of for the interagency working group, about how we can work with that. There are a few hands there. I see we have Alan and then Ellen. Alan?
Yeah, no, thank you. What a wonderful presentation and a study. And let me second that. I think having a network to share best practices, commiserate, and I love that notion of reflective practice is really a very powerful tool. A question I had for you, we often, as an ADR community, in particular with arbitrations, but this is true, I think, with any adjudication, there are critiques and challenges that come to these sort of private, more confidential practices for the resolution of disputes. Less so for mediation, but it's still, you talked about transparency, it's more private, more confidential. Indeed, that's one of the benefits of it. I'm wondering just we as CPR are always talking about ways in which to respond to those critiques and the importance of ADR as a tool for resolving disputes. This might even be heightened in the government when those challenges come. And I'm just wondering, sort of, was that part of your study, and how did you think about responding to those things or feedback you got in that area?
Well, we did address the fact, I mean, the exact fact that you have mentioned, which is anytime that we have, that confidentiality is a double-edged sword, and that there are benefits of confidentiality, but the downside of confidentiality is a lack of transparency. And there is a national movement, as we all know, really lobbied against the expansion of arbitration. And one of the things that I find is really unfortunate is that arbitrations in some areas are creating a lot of negative publicity that is affecting all arbitrations. And in some ways, it's not even part of the process, but part of the outcome and kind of where those confidentiality agreements are found, particularly as we in this. And so this did not. This isn't in the report, but to the extent that we're talking about some of the new legislation amending the FAA, what we are referring to as FSASHA, which is a very funny and awkward acronym. But especially in the arbitration and lesser in the mediation world is a question about settlement agreements and whether settlement agreements should or should not be confidential. And I think that is probably the area that is going to be the most fruitful, is questions about to what extent should resolutions be public or confidential. So I think that's going to be our next area that we're going to talk about. I would love to see it away from the process and more regarding kind of outcomes, but it's a developing area, and thanks for asking the question. Judith, anything to add before we go to Ellen?
Yeah, I would just note that, in Florida courts for court mandated mediation, the settlement agreements are the one thing that is not confidential, and that gets filed with the court.
No, thank you for your thinking, and it tracks a lot of our thinking. Maybe we should put our heads together. That's very interesting. Thank you.
Great.
Thank you. And go ahead, Ellen.
I know we're at the end of our time together, but two questions. The first, Kristen, we're both interested in ethics in these informal dispute resolution procedures. I'm surprised that these different agencies just at least would not be saying we follow the model standards, because they're so authoritative and they're out there and they're well respected. So my question is, did you see any agencies doing that? And do you have a theory as to why an agency wouldn't sort of adopt our model standards? And secondly, I was interested as to whether particular agencies require particular subject matter expertise for their mediators, whether that's part of the training that's required or part of the competency that would be looked for.
Thanks. So as to your first question, when we surveyed the agencies and asked them where they identified their ethical rules, they almost all kind of started and stopped with ADR, which does a lot, but it doesn't necessarily go all the way. And there are some agencies that have adopted or follow kind of the model standards of conduct for mediators. Where I was actually more so likely to see it was actually in the world of ombuds, and that most of our ombuds will refer to those 4 principles that have been established. I believe it's by IOA or OIA. And so I saw more consistency of adoption of external standards in the ombuds world than in the mediation world. And and maybe it's just a lack of realization that ADRA might not do all the things that it thinks it should do. And so that's my thoughts on the first question. Judith can address the training question.
Sure. Yes. As I mentioned, agencies that have a lot of technical issues tend to, really put a premium on that. And some of them also they're really attorney mediators. So like at the FCC, it's a group of attorneys in the Office of Enforcement that handle all of these, because part of what they do there is evaluative mediation. And so they're actually telling people how they think it is likely that the commission would rule on something. And this is a very popular program. There aren't too many evaluative ones, but there are some where you have early neutral evaluation, like over at the Environmental Appeals Board, for example. And there it does require subject matter expertise. And then, other agencies have found that it's more important really to have somebody that's a neutral, and that as long as it's, not rocket science or whatever, that you can go ahead and you can do that. I know that when I set up our mediation program at the PBGC, I was not that concerned about finding pension experts. I really wanted people that were very good neutrals, because we were trying to build some trust with the community and make sure that they felt like they had good neutrals that they could trust. So we went to FMCS.
Thank you.
Any other questions? I did note one comment from, sorry, I closed it. Kimberly Milanes saying she would recommend you distinguish between ADR used to resolve a formal dispute and ADR that is used to resolve conflict in the workplace. And in her agency, they're very much leaning toward prevention activities and early intervention. So those settlements or agreements would be very different from a formal settlement agreement of a filed complaint.
Yeah, that sounds kind of like workplace facilitation, which shared neutrals, which I was a member of, and I know FMCS is running shared neutrals now. And that's a program where volunteers who have mediation backgrounds go to other agencies to do mediations, and they're all workplace. And there certainly are some where you go in to really deal with a conflict that hasn't led to any kind of an EEO complaint or labor grievance or anything else, but you're really trying to work out rules of engagement and figure out what the issues are between parties and facilitate difficult conversations. And I think that Shared Neutrals has done a really good job with that.
Great. Okay, any other comments or questions? This was really terrific. And we've got a core 24 people left. So if no other comments or questions, I'd like to thank the two of you and Jeremy. Pete apologized, he had to leave for a 1 o'clock meeting, but thank you so much to the three of you for putting this together, for sharing the report and your survey. It was really terrific. And I just want to make a quick couple of announcements. We do have some other programming coming up. That's also open to the public and free. CPR is putting on a 5-part series skills training on arbitration advocacy in the virtual and hybrid world. The first program was 2 weeks ago on selecting the arbitrator, but next Monday, April 25th, is how to prepare for your procedural hearing. I think Carrie Ann is going to, if she put up upcoming events, the link, and we'll also put the link in your in the follow-up email that we'll be sending out to attendees. But this is a really valuable opportunity to take a valuable multi-part training. It's eligible for CLE credit, I believe, in New York, and the full program was sponsored by Philip Morris International. And then I would like to share with you all for next week as well, the annual spring virtual conference for the dispute resolution section for solo, small, and general practitioner division. This is something Judith is involved in, and would love for you to all look at that as well. And so with that, thank you all so very much, and thank you to those who stayed beyond the allotted hour. We really appreciate your participation, and hope to see you all